constantly emailing back and forth because they've gone to a home visit or they've found out some information that I didn't have, quite frankly, because they've taken the time and had a lot more time to kind of do that. And so the role that you guys play is invaluable. And, you know, I'd like to say that we're a team, we're all a team. You, again, you're going to see the child a lot more. And like Wayne said, you're going to have a different kind of relationship with the child.
One of the other things to remember is that when you do your investigation, you're not limited to what's in the affidavit. There may be some type of allegation made in the affidavit, and in fact, Shirley and I have a case going at the present time, and this is not the first time it's happened in this kind of case, but it's a home that's just completely unkempt. I mean, they had stuff stored in there, it was unsanitary, and it looked like a cleanliness issue when they went in, that you could clean this house up in a couple weeks and things would be okay. But when you get the children out of the home, you begin to realize that there are a lot more problems than just keeping the house clean. That the children may have mental health issues, educational issues, and don't limit your investigation.
Right.
And I don't know whether you found, I've had a couple of these cases where the house is just filled with trash and everything. And
on the surface, it looks like that's the problem when CPS goes in. But I think just by the mere fact that the house is in the condition that it's in says there may be something else going on. And most of the time what we find is there is something else going on. The case that Wayne is talking about in particular, you get in there and you get the kids out of there and you realize that one of the kids severely autistic. I don't even think I'm saying that word right, but autism.
Yeah, that's right.
But just, you know, pretty severe. Another child with those kinds of symptoms and so was acting out very badly. So just a lot of other things that were going on that on the surface, when you look at it, you think, oh, just a dirty house. Now, let me tell you, it was a dirty house. And dirty is not even the word. It was a filthy house. But once we got the kids out of there, you began to see that there were some other issues going on as well.
One of the other things that the GAL must do is advise the child in terms that the child can understand of the nature of the legal proceedings. Again, the age of the child makes a big difference. You know, it may be when you've got a 5 or 6 year old child, you sit down and say, look, there's an issue, you know, in how your parents are taking care of you and we're working on that. You get a kid that's 16 or 17 and you can be a lot more specific about how the proceeding is going to go, who can present evidence, what the arguments will be, and what the likely outcomes might be with the child. A lot of times we may even need to talk with a mental health provider if you've got a child that may be severely depressed. The counselor may be able to tell you how to approach telling the child what's going to happen, whether it may be a residential setting that they're going to go to, or maybe they're going back with mom or dad that they've had problems. But we can look elsewhere to get help in telling the child what's going to happen. I found that with most kids, you know, once they're grade school or older, I'll give them one of my cards and tell them to put it in their pocket, keep it in a safe place, because they have someone that they can call. And I imagine that's probably something that you do, that you give them a card and they know how to get in touch with you if there's any emergency. You tell them, call 911 if there's a question of your safety. If you have a question for me, you can call me anytime and I will get back to you. Is that something that you do too? Or?
Absolutely, absolutely. In fact, I called a kid back at 10 o'clock a couple of weeks ago because I called into my office. I had left the office and called in probably about 10 minutes to 10 at night in the evening to, you know, just check to see if any calls had come in. kid had called, and I was like, oh my God, And so, I called her back at 10 o'clock at night because I didn't know what was going on, if there was something going on. And, I encourage them, if they have issues, if they have questions, if they have concerns, to give me a call. Now, she wanted me to know that she had done well in school, and I was happy about that. But I was like, well, I guess I could have called you tomorrow on that one. But
One of the things I've got here on the outline is to maintain meaningful contact during the term of the service. And I guess age is a factor, but I've now got kids that I was appointed to when they may have been 2 or 3 years old who are now turning 18 and unfortunately have remained in the system off and on over that period of time. And in some cases, it's nice to see that these kids have gotten to the age 18, they're going out on their own, and the system has worked for them, that they've taken advantage of education and all. But I've got a kid coming up, I think in about a month, that's going to turn 18, that I started with when I think he was 4 years old. And he's turned out to be a pretty good young kid. I've got another one I'm going to court on Monday that I've been involved with for probably about 6 or 7 years. Just a horrible situation where mother and father couldn't take care of this child. They lost 5 of 6 other children. Grandmother and grandfather took custody of her. And this is one of the few homes I'd been to where you just couldn't get past the front door because of the odor in the house. It was just too powerful. And this girl went to live with her grandmother and grandfather in a mobile home park down in Richmond, which had to be 50 years old, but was a step up from what she had been in. Well, her grandmother died, and we're going to court on Monday that there was mother and father in the church that she was going to that had taken care of her youth group and have taken her into her home now, into their home. She has really matured into a nice young teenager who has thoughts of going on to college, is now healthy and well taken care of. And you just never know where people are going to come from to try and help these kids in their lives. And your influence on them, even for short periods of time, can be extremely important. We'll also participate in any conferences and meetings prior to a court date. There are cases where we will actually assist our wards in preparing for testimony. There may be a case where there's a protective order because of family abuse, where the child will have to testify in court, and we will go over their testimony. We don't try to influence their testimony. What we try to do is get them, or what I try to do is get them to remember the facts so that they can tell the story the way it happened and not be programmed to certain answers.
I had a case last summer, a case where I represented a child who had been raped by mom's boyfriend. And in that case, I spent a lot of time with her just trying to help her get comfortable with the idea of going to court, because it's the prosecutor that's going to primarily be prepping her and with what it is that she needs in the courtroom. But I felt like it was my job to be there with her every day, and the trial went on for I think 3 days. So I was there all day, every day for 3 days, but just there as somebody that the child knows, she trusts. You're going in there at 11 years old, you're looking at this judge and this jury and all of these other players in there, and so I saw my role is more of a support, and just to kind of I picked her up 2 days before the trial started, took her to the courtroom so that she saw what the inside of the courtroom looked like, so that she wouldn't be, I told her where the bailiff would be standing, I told her where the gentleman would be seated, just showed her all of this so that, she was at least comfortable as she could be, going into a courtroom at 11 years old.
One of the roles that we do not fulfill is that of a mediator. Although I tend to feel that both sides, at least in our practice, both the county and the mothers and fathers attorneys will tend to respect what a GAL says and take that into consideration. And there are times that we can go to an attorney for the mother or father and say, hey, look, it looks like this is going to happen, and you might be better off to take this course of action than that course of action. But we're not mediators, but we can try to help the child. There are other types of meetings that we go to. Shirley, do you go to IEPs? And
I do. I'm at the school. I go to the schools. In fact, I had one on Wednesday, I believe it was this past week, at a school, just trying to update a kid's IEP because we didn't feel like the last one, unfortunately, that he had was like 2003, and so we knew that there were some other things that had come up in his educational plan that needed to be updated so that he would be getting an appropriate education. I also go to the CSTs and all of those things, and most of the time the CASAs are, I don't know that, there wasn't a CASA at the IEP meeting, but most of the time when I go to CSTs, CASAs are there. And so we try to, if there's something that's involving the child, I try to make a point, if the time is available in my schedule, to make those meetings. Now, I have in the past coordinated with the CASAs to say, hey, are you going to be able to make this, because I can't make it, and that has worked out really well.
I guess mainly the one thing that I'd like to impress on you is that communication between the GAL and the CASA really is helpful, and I think it'd be helpful for both you and for ourselves. We only have a couple minutes left, and maybe if there are any questions, if anybody has a question, we'd be happy to try and, yes?
Yeah, I wonder, could you just give an example in Virginia where the legal interest of the child is sort of distinct from like the abuse and neglect statute? Like what is an example of a legal interest of the child that's really not just about proving neglect or abuse and sort of distinct from the parent? I mean, do children have statutory rights to, I don't know what. I'm just trying to think of an example.
Well, they have all of the, I don't want to say all, but most of the rights that any other person has, and often terms those legal rights might be a placement which is in the nature of restraining their liberty. That, as I mentioned, the child that may go off to a residential treatment program, they're restrained. And is this in their best interest to be deprived of their liberty, or is it in their best interest to be separated from their parent at any given time? Yes, sir.
We've heard in past sessions, and you alluded to it, occasionally there's differences of opinion between the CASA and you folks. Are those situations institutional character, or is it sort of idiosyncratic when you do have differences of view? Have you ever had this happen?
Well, I have, absolutely. But I think I've only had that happen in one case. In fact, it was the case that I was just talking about with the child that had to testify against the mom's boyfriend. I think part of the problem was, I'm not sure what the problem was, but we did have a disagreement. And, I just had to tell the court, I totally disagree with what's in the report, but it was because I had information that she didn't have, and maybe had we communicated, because it painted a picture that just was totally not accurate in my assessment, and I just had to tell the court that. Now, the CASA and I talked about it afterwards, and I said, maybe had we talked, and I would, and I accepted some of the responsibility for that. But I was just shocked when I read the report because I knew that the information, I had talked with the therapist, I had talked with, 3 or 4 people. Not that this individual hadn't done that, but I think at the point that she had done it, there had been some significant changes. And so it wasn't updated information.
Yes, sir.
You had mentioned that you couldn't be a mediator or so, and also talked about discussions that are in the lobby of the courtroom where you're trying to get agreements. Is there a formal role for alternative dispute resolution in this process?
Not right now. I mean, they have tried in the past. There was a system about 5, 6 years ago that when an abuse and neglect case came in, everybody was going to meet in a private meeting at 9 o'clock in the courthouse, and that everybody being the GAL, CASA, the social worker, assistant county attorney, would all meet, discuss, and try to have a resolution by the time it got to court. And that system didn't really seem to get anywhere.
They have that kind of system in DC. Again, I don't take those cases anymore in DC. They have, I think all of the abuse and neglect cases go to mediation. I don't know that I think that's helpful at all from the mediations I've been to, simply because I think people already have their minds made up. That's why they filed their petition. So
I also tend to think that the cases that we do get are serious cases.
right.
They've weeded out a lot of these cases where mediation or some other alternative might be available before it gets to court. So if it's in the courthouse, most of them are pretty serious cases. So, yes, ma'am.
Your relationship with these children that you've had in your system for maybe 12 or 13 years must extend past the professional relationship. Do you think you become a mentor, or does it, for all that length of time, is it just remain professional, or do you kind of cross the line to be a little bit more than?
I would say it remains professional to a large extent. I mean, I see the child in connection with court proceedings. I do not go and see the child periodically for recreational or other types of activities. So it's tended to stay on a more professional basis, but the more you see somebody, the better you know them and the closer they feel to you. So.
This is sort of a logistics question. There was a program on TV years ago called Judging Amy, where she did essentially what the judge what we're doing. I'm interested in the size of the courtroom. I mean, are the courtrooms small so that children don't feel absolutely dwarfed? Because I was on a jury once, and the courtroom was pretty large. And I think, my goodness, if I brought an 11-year-old in there, what would they think?
Well, I think it depends on where you are. In the juvenile court, they're pretty small.
Yeah.
In the juvenile court. Now, I haven't been to the new courtrooms that belong to the juvenile court in the main courthouse. Have you been over there?
I have not been in any of
So
this.
I don't know whether that's, large or small. I just don't know. But here, just because this is a very old building, first of all, they are pretty small. But you know what? I don't tend to have a lot of kids come to court. I don't know about you, but
Yeah,
most of the time there's not a need. If they want to come to court as GAL, I'm going to advocate, especially if they're over. I always tell people over the age of 13, if they want to come to court, then they certainly have a right to be there, and I'm going to advocate, that they be there. So, but for the most part, we don't have kids in that juvenile court every day for abuse and neglect cases. In fact, I'd say it's the norm not to have them.
Yeah, I think that's true. Very rarely is there a child in for an abuse and neglect case. Now, I'd say roughly half to 2/3 the size of this room is the typical size courtroom that we have across the street.
Part question. When exactly is the GAL appointed? Is it at the 5-day hearing, or what? Where in the process does that happen? And then you spoke about how you continued as the GAL
for long periods of time for some children. Even after they're returned to their home, if that's the result, in the end, once a GAL is appointed to a child, do you continue in that role until they're 18, or do your services terminate at some point for a particular child?
I'll speak. First, we're appointed very early in the case. Generally what happens is the social worker will come in with a petition for an emergency removal. That petition goes to a judge in a courtroom who will look at it and decide whether to take the child out on the emergency basis. If that petition is granted and an order is entered to remove the child, a GAL will be appointed right at that time and will be called within a day or so of the appointment. And so we will generally get it 3 to 4 days before the 5-day hearing is concerned at that point. So we're right very early on.
And for the second part, I think it really just depends. If a child is returned home, the case isn't just closed. The case is going to remain open for a period of time. And so we're still going to be GAL. Now, once a kid turns 18, they're no longer entitled to a GAL. But prior to that, if the kids are returned home, we are still their GAL up until the county closes out the case. If for whatever reason the case comes back, let's say 3 years later the case comes back into court, then we would be reappointed as guardian ad litem on that case if we're still.
The child has one court file for their entire life, so that if that case comes back in, the clerk is going to reopen that file and see who was appointed before, and they'll call to see if we're still available to do it. So, well, thank you very much. Look forward to working with you.